Thank you so much for joining us today. We really appreciate your time. We are going to be discussing Local Law 97, and we're joined today by the Empower Group, Michael Scorrano and Mitchell Karasik, who both work for Empower. Thank you so much for joining us today, gentlemen. Appreciate your time. I'm Elise, Senior Vice President here at AKAM. And from the AKAM side, I'm joined by Matt Cebula, who is a Senior Director of Energy here at AKAM. And thank you, Matt, for joining us today. Appreciate your time. Before we get started, do you want to just share a little bit about the Empower Group for our clients that are joining us today?
Sure. I'll start it off. I'm Mitchell Karasik with Empower. I handle our business development and sales. And just a little bit about Empower. We are a mechanical engineering design firm. That's our focus, with the main focus being on energy efficiency, carbon reduction, and helping people comply with local laws, such as Local Law 97, as well as all incentives that might be available for things that a building might do relating to energy efficiency. So we can help everything from helping to design and replace a boiler system, move somebody onto gas, and certainly with compliance and energy studies like Local Law 97. And with that, I'll let Mike kind of take it from there and a little bit more.
Great.
Yeah, and I'm Michael Scorrano. I'm founder and managing director of Empower Group, and certainly Mitch gave a good introduction about all that we do with buildings. So certainly very happy to be here, and thank you for the invite. And certainly work on a number of AKAM buildings with Matt and the rest of your team. So again, appreciate the opportunity to kind of give the folks that are on this call today just a background of a little bit on 97, but really, where we are right now and what needs to get done in the next two months or so in order to basically be in compliance with Local 97. So I think it'll be informative from that perspective.
Wonderful. Thank you. All right. So we'll get started. I know that this is a pressing situation because this is due May 1st. All right. Michael or Matt, whoever wants to start.
Yeah, I guess I'll kick it off, kind of give a high overview. So Local Law 97 was a centerpiece of the Climate Mobilization Act, which was introduced in 2019. And it's hard to believe that it's 2025 and we're looking at our first filing period for Local Law 97, where technically 2024 was the first year of compliance. That's the year where your energy data will be reported this year. The target of the law is essentially, in short, an all-electric New York City come 2050. There are stringent carbon emissions caps that you need to meet through the different cycles of the law. We're entering the first cycle, which will run from 2024 through 2029. And regardless of whether or not you're over or under those carbon caps, your building, if you're over the square footage limit, which is 25,000 square feet, has to submit an annual report to the city indicating what your energy usage was and how that translates to carbon emissions. The DOB put out a number of updates, I guess up to the 11th hour with regards to, the reporting structure, their new filing platform, which is called BEAM. A part of the requirement is to engage a registered design professional, an RDP. And the Empower Group is one of the RDPs. They are doing a number of 97 certifications and filings for AKAM clients, which is why we have them on the call. And essentially, we just want to give you guys an overview of what the law is, what the changes were that came out with the updates from the DOB, and the different sets of requirements that you need to follow in order to make sure that your building is compliant. Michael and Mitchell will discuss the latest and greatest when it comes to the extensions that were granted by the DOB. There's stuff that literally came out from the DOB yesterday about extensions for the benchmarking. That all has an effect on your 97 filing in a positive way, that it gives us more time to make sure that these are completed on time and with the correct data. So Michael and Mitchell, I'll let you guys take it away.
I was just going to ask really fast, what does RDP stand for?
Registered Design Professional.
Here we go. All right. Thank you.
Okay. Right, which could be a professional engineer, which I am, or a registered architect. So they all kind of encompass under the RDP umbrella. But I am a PE registered in New York State. So.
Great.
So again, thank you with that, Matt and Elise. So we just want to kind of get into it. So again, Matt went through quickly what, Local 97 and how long it's been in play. But and this is the first year where Local 97 has to be reported based upon the 2024 data that we or you used or accumulated in the building last year. So there are 4 compliance pathways that buildings could take that are going forward. So there may be some people on this call that are not due this year at all, and I'll get into why that is. Or there may be others that may have buildings that could actually get a one-time exemption and just move on. So if you look at the different pathways, there's one that they call Article 321, which we're really not going to talk about too much today, but that would be if your building happened to be more than 35% affordable, and that you could actually do a one-time sort of prescriptive measure and have an RDP sign off on those, and you would never have to do anything ever again for the entirety of Local 97 through 2050. So that would be good if you fell into that category. That's probably not the case for most. Most people will fall into what they call Article 320 typical pathway. So if there's no affordability component, which I'll get to the other 2 boxes in a minute, you will be due this starting technically effective May 1st. There is, and it's due every year from that point forward. So every year, May 1st, we have to file with the city for Local 97. There, we'll get into some of the extensions for this year that are applicable that, as Matt said too, some of them came at the final hour, some came towards the end of last year, but all for the positive because the DOB, they do and have an enormous task at hand to make sure that Local 97 does get reported, hopefully accurately and fairly, and that, that we can kind of come up with solutions for buildings that have penalties associated with them and hopefully work to try to get around those through either energy efficiency upgrades or some other path that they put in place. And the other 2 pathways, again, Article 320, which is the 2026 pathway. So that's for buildings that have, at least one rent regulated or building or one regulated unit, but less than 35%. Those particular buildings are not due until 2027 will be the first filing. So you literally have a 2-year reprieve, 2024 and 2026 from an energy perspective, 2025 and 2026 from a filing perspective. And then there's also other buildings that are income restricted. Mitchell-Lama buildings would fall into this. We have a bunch in our portfolio that we work with, but they are not due to do any filing until 2035. So again, they, because of their status in terms of affordability, do not have to comply. But for the majority of buildings that we deal with in the AKAM portfolio and across other portfolios, they're either typical pathway, which they're due this year, or they're going to be due first time in 2027. That seems to be the norm for most of the buildings.
Got it. And so affordability has a factor, but age would not.
No, age has no factor or anything. It really just looks at affordability. As long as it's over 25,000 square feet, like Matt showed that number before, and the building is under the Local 97 umbrella. And again, depending on affordability makeup of the building, you'll either be due now this year in technically May 1st, but we'll get to the extensions in a minute, or you'll have a push out to 2027 or even 2035, depending on the amount that you have there.
Yeah. And sorry, really quick. So if you're a newer construction, you will also be, if this will fall into the category of you will have to comply.
Yep. Yeah, new construction buildings as well. Again, it doesn't really differentiate between any of those buildings. It really just looks at, if you're a building and you have a C of O in the building and the building's occupied, it must comply with Local 97. And we'll get to that. There's going to be a slide coming up about covered buildings list of where you check to make sure that you're actually due. But you're, again, even if you're not on that list, but you meet all the other criteria, technically you're supposed to be complying.
So now
we'll get to that in a second.
Perfect. And then as far as non-compliance is concerned, I guess that's what you're going to discuss.
Yeah, we'll get into that. So again, this is the law of the city. Buildings have to report starting this year. The filing due date is in 2025, and the fines are pretty steep. If you don't file for a Local 97 Article 320 report, there's a penalty of 50 cents per square foot each month past due. So again, if you just as an example, if you had a 100,000 square foot building and you failed to file, it could be a $50,000 penalty per month for non-filing. So they definitely made it very egregious to buildings for not file for this law. So again, it is very important that people understand that we're here to help file these buildings, and certainly you need to. And again, I will also say that most buildings, even if you are due this year, under the way Local 97 works, it has different tranches. Like I think Matt showed before, that they want to be 40% carbon reduction by 2030. They want to be 80% by 2050. So they have sort of lowering scales over time. So most buildings, at least the first compliance period, which ran from 2024 through 2029, most of the buildings in that tranche don't have a penalty. I will say there probably are some that do, but again, most of the buildings don't. So it's just more a type of thing where you really just need to be on top of it. And even if you had no carbon penalty and you failed to file, these are the penalties that can be levied upon a building. And again, for buildings that do exceed their emission cap, and when we actually do our calculations of how much carbon either is over, if you happen to be over for this year, they have a formula of $268 times the amount of emission exceedance in terms of metric tons. And those are calculations we do as an RDP when we submit and file.
Great. And then Matt, from an AKAM perspective, how are we handling the compliance filing?
So we came up with a comprehensive filing package that we distributed to all our clients. It combines our benchmarking provider with the RDP, one of them being the Empower Group. So there's layers of review when it comes to the data before it gets submitted. And at the end of the day, I mean, it's Michael who's going to have the final look over and basically putting your professional license on the line, no, Michael, with every submission, right?
Yes, and actually in the law, it also talks about penalties for us as RDPs for, basically if for some reason we didn't do our job. I mean, happy egregious, but there's a $500,000 fine number listed in there, and it might even talk about jail time. So neither of which I want to have anything to do with. So yes, it's important that we work with AKAM's team, the benchmark provider, and ourselves to make sure that the data is correctly put together and properly filed. And certainly it is, again, we're something I am putting my professional license on the line for doing. And I've been a PE, since 1999. So certainly now coming on 26 years. So certainly something I've had for a while at this point in time.
Wow. We don't want you going to jail.
No, that's no good.
How do you check?
My family likes me.
I think people would miss you. How do you check if your building is compliant and your status?
Yeah, so the DOB does have a thing on their website where you can actually check to see if you're on the local law 97 covered buildings list. So if you just Google local 97 covered buildings list, you'd actually go to the website that we would go to as well to double check. And you can look up your building by address, you can look it up by BBL number, and there's various ways to kind of look at that. So again, we use this criteria most of the time to look just to reconfirm, is the building due this year, or does the building have any type of affordability exemptions? Because sometimes people don't realize that there is at least one residential unit meets the affordability criteria. The DOB has picked up on that and has pushed them over to the 2027 filing. On the flip side, we've had buildings that we know meet the affordability but are actually on the covered building list for this year. We actually have to then go back and do an appeal and then get them changed to their proper stuff. But the website address is also there, but basically you can look to double check to see when your building is due, and again if you have any type of pushing it out because of affordability stuff. But this is definitely something for everybody that has a building that's managing it to double check just to see when they're due and just to make sure they're on the list. But irrespective of it, if you're not on the CBL list, just like the third bullet point says, but you meet all the criteria, like you're over 25,000 square feet, you're a building in New York City, all those other things, in theory you are supposed to file. So we would always advise filing with that, just to make sure that you're not going to have any penalties that could be set in rear because you just happen to not on the list for that particular second.
Understood. So, and then going back, you were just saying that the key component was the gross floor area, right? So that affordability is a factor, but more so is the gross floor area.
Right. So the law talks about carbon per square foot, right? So that is obviously one of the big criteria is in there, because when the city looks at the metric, they try to break down the property into various use types, which is one thing, but they also look at the gross floor area of the building. And the gross floor area is actually a definition in the Local 97 legislation. So most people are familiar with the Department of Finance's gross square footage calculations that are out there, which is the DOF, which is actually the second bullet point of this. But those calculations typically exclude, I'll call it non-revenue or non-rent or sort of like areas that are not amenity spaces, or they're mechanical rooms or things that would not be included for any way to have income generated from them. So those are generally excluded. So we always find typically that the Department of Finance number is going to be lower. So the law does require that a registered design professional sign off on the gross floor area of the building, and it is required that a gross floor area calculation be done or certified and signed off by an RDP like myself. And also, not only is the gross floor area, which includes all area of the building from, floor to ceiling, wall to wall, every square footage we want to account for, because that will help us minimize that'll help us maximize the amount of carbon we're allowed, help us minimize any carbon emissions that we would actually pay. And again, it's required for us to sign off on that by building type and square footage. And again, we would recommend that, we recommend that it's being done, and it has to be actually done for the RDP to sign off on the calculation when we submit them to the city.
So this is different than before when they were just issuing grades and they had, incorrect information. And so sometimes your letter grade was off because the information provided was not correct and accurate. So in this case, this is going to be accurate information that's presented. And so there's no workaround after the fact.
Correct. Well, yeah. So with gross floor area, at least for the first year, actually, we can make an estimate as long as I, as the RDP, are comfortable with, making an estimate. And the Department of Buildings does allow for us to do estimates through, satellite data, map data, building drawing data, and there's a lot of other things that we actually can use in order to, at least for the first year of compliance, be able to come up with a more accurate representation of the gross floor area, which they want me obviously to sign off on. And then we do have the ability, afterwards to basically update that data if we, go and actually went out there and did a measurement because we found that we wanted to do that after the fact. So there is a good thing on that because, we have a lot of buildings that are coming to us right now at the final hour and saying, hey, we have to file, like, great, where's your gross floor area calculation? We don't have it. So obviously there's a lot of time for us to kind of go out there and do those measurements to accurate. So we are able to at least do the estimates for this particular period and sign off on it based upon breaking down the area into use type and area. So that will be obviously something we can do, and we can certainly go and modify that later. But yes, overall, the Local 197 is a much more rigorous procedure. And I'm certainly, at least through the AKAM portfolio, we're lucky to be working with Matt's team and with your building benchmarking provider, because between all the different parties, we have a lot of opportunity to, the benchmarking provider gets all the data. They're going to do a first pass of it. We're going to take a look at it as well. We're going to make sure that the energy use data, meets certain criteria. If we see there's anomalies, missing oil, missing this, missing that, or just producing area, high carbon penalties, just looking at the data first time through, we'll go through that, and we'll go back to Matt's team and the benchmark provider and try to come up with what's happening with that. Because ultimately, of the day, I'm going to sign off on it and send it in there. And the good part is too that not only because of Local 197, I think the Local 84, the benchmarking law, is also getting more accurate, because we have to get, very accurate usage data plus the square footage, which the gross floor area that we have here. And then, that's all feeding back to make, better product overall. So hopefully we'll see a little bit tighter improvement on the benchmarking as well for the letter grades, as well as us trying to maximize gross floor area and minimize any carbon penalties associated with buildings forward.
Understand. So they're going to all work together essentially.
Mm-hmm.
And so that brings up, so you already mentioned 84 and now local law 88 as well.
Yep.
So it's another key compliance area that people need to think about.
Yeah, the reason for just bringing it up here is because it is a law that's been on the books a long time, but its first year of compliance is actually due in May 1st as well. So another law due this May. And there are some abilities to get extensions as well. So as long as we'll get to the extensions on the Local 97, but if the building is eligible for an extension for under Local 97, Local 88 will actually follow suit. So Local 88 does two things. It mandates buildings look at energy efficient lighting. So it requires us to look to make sure that the building meets the current energy code of lighting that was installed over the past 10 years or so, that it meets those criteria. And also, if it was a building that had a lot of commercial spaces in it, we have to make sure that there's proper sub-metering involved to basically meter any space that's over 5,000 square feet. So again, this is another law that does affect also any building over 25,000 square feet, and it also is due on May 1st. There are penalties associated with not filing this, not as egregious clearly as the Local 197. For the lighting portion of the law, it's like $1,500 if the building doesn't comply this year with it. So we do have some buildings that have a lot of work to do. So they'll just take the penalty and they'll move on and they'll file for next year. On the sub-metering side, most of the time, like I'll call it the majority of multifamily buildings we work in, don't have any spaces that are over 5,000 square feet that happen to not be already metered. So that's something we sign off on, even though that would have a penalty if we didn't follow through with that. So the point is, you really also just need to think about Local 88 in conjunction with everything that's due this May. And if you haven't heard of this law and you haven't done anything about the law, as part of the process here, you should engage another party. And again, could be us or somebody else to basically also submit for compliance for Local Law 88, because again, it does require a registered design professional to also certify that the building meets the energy code in regard to lighting, and that the building also is sub-metered properly in regard to sub-metering to meet the requirements of the law. So that's just wanted to make sure I put it out here, because again, it is something that sometimes people forget about, which needs to get done.
And then as far as the lighting systems, what kind of lighting systems are people looking at?
Yeah, most of the time it's looking to make sure the building has LED lighting in the building. But if your building's not 100% LED, doesn't mean necessarily you won't meet the proper criteria of the energy code, because the energy code does look at lighting power density, or how much energy you're using per square foot in regard to your lighting. So, but they really should be looking to make sure that if you have at least the majority of spaces are LED. And we know that if a building has a majority of spaces LED, the building will comply with that portion of the law. The second portion of the lighting law requires a lot of sensors. So depending on when you did the upgrades of your building, will require more or less sensors associated with it. And when I say sensors, or occupancy sensors or vacancy sensors. So, the law wants to have, bi-level sensors, an example, in stairwells. The law wants to see, the energy code law requires that you have it in unoccupied spaces, have a sensor that turns lighting off. There is some interpretation, depending on how old the building is, having it in hallways. So, and garages as well, having 70% of the fixtures turn off when the garage is unoccupied. So, and keeping 30% on. So these are all things that have to be looked at when we kind of look at these buildings and make sure that we meet the current energy code, depending on when the lighting was done. So the lighting had to be done after 2010. So that is one criteria. And there's another sort of break point around 2020 that, depending on if the projects in the building were done after 2020, we'd have to be a little bit more stringent on the sensor side. If it was done before 2020, we could go off the older code, which didn't require maybe as many things. So really, that's when you get an RDP like ourselves involved to kind of assess the lighting, look at opportunities for energy efficiency as well as compliance. And again, what I will say about lighting is it's usually the lowest cost hanging fruit. So usually lighting pays for itself anywhere from 2 to 4 years. So if you haven't really upgraded your building to LEDs, it definitely is something that's going to be beneficial for the building. And if you don't have a proper space sensors in there, those are other things that actually also will help the building. And again, the more energy we can save on lighting, it's just less energy that we're contributing to carbon, and therefore it does have a benefit as well in a carbon penalty.
Understood. Thank you. Matt, from an AKAM perspective, I know in the past there were some energy grants, to help with lighting updates and other types of energy updates. Are those types of things available for buildings that might be concerned with all these costs with, compliance and might not have a ton of reserves? Is there anything available?
Yeah, I mean, there are still incentives for lighting that will be coming from the local utility. However, you have to realize that LED and that technology has become so inexpensive that those incentives are slowly dwindling down. So if you still have work to do, this is a great opportunity not only to become compliant with Local Law 88, put it to bed, because all you have to do is file it once and you're done with it, and then still access whatever incentives are available for the upgrades. I mean, like Michael mentioned, it's really not converting the entire building to LED, but it's something you might consider when you do your Local Law 88 survey. You might want to break it up into what do you have to do to be in compliance, and then what can we do on a building scale to make sure that our lighting is the most efficient while there's still money out there.
Right. So what are some good faith efforts?
So we'll get into this. So part of the law would be that it does give some avenues if you find out that your building does have carbon emissions in the first round of from 2024 to 2029. But the law does define various mechanisms, that things that could sort of help the building out to try to minimize the carbon penalties associated with that. One of the big ones that they have in there is called mediated resolution. So if you happen to be a building that all of a sudden the RDP turns around and says, hey guys, you have a pretty big carbon penalty associated with this, there are potential ways in order to help minimize that. One of them, again, is the mediated resolution, which allows us to put together a good faith effort plan So we have to look at whether or not could we, if depending on what we could do in the building, could we put together a plan, an action plan that would help us reduce penalties in order for us to meet 2024 carbon emissions by 2027 and 2030 by 2030. And if we could basically do those things or put those plans in place and hit these targets, then the city would basically forgive the first or second or third year of carbon penalties associated with it, because you are demonstrating good faith that you're working with the city or in good faith to try to reduce carbon emissions and put that plan in action. And those things could be, just a decarbonization plan looking at energy efficiency measures, which is good, or looking at some type of electrification measures that would help reduce the amount of fossil fuel being born in the building. We're certainly, bigger fans of some type of electrification. So, systems that will say for domestic hot water heating, as an example, we can more easily switch that over to electrification. Other projects become, depending on very building specific, a little bit harder to do. But again, if you happen to be a building facing carbon penalties in the first compliance period, and obviously nobody wants to pay penalties associated with them to the city, there is other avenues associated with basically getting out of them, at least for the first compliance period, by working with us or another RDP, or to put together a plan to show the city you are serious about reducing carbon, you have an actual plan in place, and you're demonstrating and moving forward that those fines can be forgiven for the first period of time. The second part on compliance is that they finally, in the last couple of weeks, defined how, if buildings are meeting or do have a carbon penalty, how they can actually go forward and actually buy carbon offsets. The only thing I will say on the carbon offsets is the carbon offset actually equals the price of the carbon penalty, but it was a way that they basically put in place, and I guess we lost some language there, but what that was supposed to basically say is they put together a plan that would allow buildings who need carbon offsets to buy them from basically affordable buildings who are making investments in energy efficiency measures, and sort of use that to help fund those measures. So it's a way the city has put that together to help do that. There's no other way that you can buy carbon offsets, but at least in the law it originally defined that there would be carbon offsets, and the city finally came out with their plan. The plan is mostly, again, you have to buy carbon offsets from lower, affordable buildings that are doing energy efficiency measures and may have a surplus of carbon to give. But again, it doesn't really save you money. It's just like instead of paying the city a fine, you're paying for these other carbon offsets and essentially complying with Local 97 and hopefully, helping to, fund or incentivize other measures that are out there. But I just wanted to kind of throw that up to let people know
So
that.
an offset just be money towards the city using it for a better purpose of other ways, but you're not.
Yeah, instead of sending the money directly to the city's coffers, you're actually sending it to a special purpose, like to maybe an affordable building who can't afford to make these investments, but by you paying your carbon penalty to that fund, they're using that fund to fund those measures. And that's all administered through NYSEG and the accelerator. There's a bunch of city agencies that are involved with that. And again, it doesn't necessarily help the building save money. It's just a way to, instead of, again, sending it to the city, to a pot of money we don't know where it goes to, it's sending it to for a purpose, right? So it's like making a charitable contribution some other place instead of having to pay your taxes. It's almost a similar sort of type of thing. The other one that's here, beneficial electrification, that is actually an interesting one that's out there. So if you're a building that is potentially facing a carbon penalty, or maybe looking for ways to kind of help comply with it, and you do any type of electrification now, there is a thing called the beneficial electrification credit that will basically apply to for the next 5 years against your carbon penalty. So if you did a project now, or if you didn't have a carbon penalty for 24 through 29, you could actually bank those credits for your next compliance period where you may have a carbon penalty. So we find buildings that have made switching, like we have a lot of buildings that had old gas-fired or fossil-fired chillers, and they've gone to electric air conditioning. That could be potentially a building that if they were facing a carbon penalty in 2030, we could apply a beneficial electrification credit for years 2030 through 35 and help them actually save some money, because they kind of jumped on the electrification bandwagon before, and the city is sort of giving them credit for doing that. And we also have buildings that are, been looking at some type of electrification of domestic hot water heaters. And when we apply the beneficial electrification credit to those, it actually makes those paybacks look actually pretty good and avoids carbon penalties down the road. So those are definitely things to be looking at going forward. Once again.
We have a question here, which is, what does the graduated carbon reduction schedule look like do pre-war buildings have a realistic chance of meeting these goals and avoid penalties without huge annual investments in building infrastructure?
So again, the way the carbon penalties work is the city define a certain cap that's going to go down each time over years. The only thing that I could say that would be helpful for any type of building is that, excuse me, as in a parallel path, the state is also looking at doing energy efficiency work and making carbon-free electricity. So as buildings start buying more electricity in the future, that'll be on a much lower carbon basis. So again, in my mind, as long as the building can kind of maybe hit their 2030 target to 2035, as long as the state also gets very clean energy, the building will naturally just ride down the carbon emissions because, again, the electricity they're consuming is much more cleaner. So I think that's really where buildings have to look at is like, what can I do to make my 2030 to 35 goal? And then assuming the state also complies with their plan of putting in, fossil-free electric generation, and they are moving forward to doing that, it should be a normal order to basically help you kind of come down. So I think it is possible for a building, post-war, pre-war, all that, as long as they can meet their 30 to 35 goals, they can pretty much ride the curve down as the electricity in the market gets cleaner and still stay in compliance going forward.
Does this have anything to do with the gas versus electric oven, your stovetop rather, that was also up for discussion?
Yeah, I guess the answer is a little bit. Certainly, I mean, you have to start with the premise is, do people still cook, right? And if we say they do, then obviously if they switch their oven from gas to electric, it's going to have a sort of impact on the building. But really, when we look at buildings most of the time, the electric oven compared to a gas-fired oven doesn't really contribute very much to carbon emissions in the building. Certainly, if the building is being brand new, obviously any building over after 2027 for new construction has to be, fossil fuel free. So all that stuff's going to be electric. But if you're an existing building and you have gas stoves, again, that's not going to contribute very much to carbon penalty. Obviously, if you somehow lost your gas and you needed to look at other options, maybe looking at electric as an alternative at that point may be beneficial, because now if I upgrade the electric infrastructure, I can do these other type of measures for electrification down the road. But again, that has kind of a smaller impact to buildings.
Are there any, ideas that you can share with buildings that might be older that, do have a good impact that are, maybe cost efficient? You mentioned the chiller.
Yeah, so I think any building has central chilling, so we have buildings, certainly buildings that are built in the 50s and 60s and in the early 70s that had a chiller, air conditioning equipment that was running off of fossil fuel. It either was Con-Ed steam, it could have been off of boilers, steam that was made in the boiler. It could have been something that burned gas directly. Converting any of that over to electric air conditioning is going to have a huge impact, not only from a cost perspective, irrespective of carbon, but also from a carbon perspective. So that's sort of one building type that anytime we come across a building that has an old AC system, again, 50s, 60s, early 70s vintage, those are always good ones to do. Sort of older buildings, we like, separate domestic hot water heating for summertime operation could help convert some of the gas usage over to electric and also give us that beneficial electrification credit that I was talking about on this slide as well. So that's something that could possibly play. So when we look at buildings, it really just depends on, the building type. So if it's like pre-war, if it's a post-war, if it has a central heating system, if it's steam, we look at all that type of stuff. And in our general view is looking at just trying to, get on a lower carbon use of fuel. So if you're oil, you should definitely be on gas. And that'll be one thing. You should always then try to and then if you are going to go to gas or stay with the gas system, how can I be the most energy efficient as I can? That's great. How can I then switch some of my usage over to non-fossil fuel? And that's where the separate hot water heaters come in. We do have some buildings that certainly are looking to do full electrification, and that's fine. If they have the budget, they can support it. They have other reasons sometimes for doing that, because sometimes now they can do heating and cooling in the building. They're not stuck to having just a heating system on or have their air conditioning system running in the summertime. So it really just depends on the different type of building. But definitely there is, for any building out there, there is a way to reduce energy, save energy usage, reduce carbon. We may or may not get to the full value of the carbon penalty, but we can at least try to make a cost-effective try and at least present the buildings back with various options they can definitely consider. And again, we definitely like, central we like electric air conditioning and central heated and cool buildings. We really like, separate domestic hot water heating systems, either electrification or separate gas ones in particular. And we definitely like energy efficiency measures, in general, which are the same things we've been doing the last 20 years, which obviously anytime I can reduce energy is going to reduce carbon and help buildings comply. And again, with us at least, we always try to look at things that are cost effective and try to make recommendations that we feel are going to be, going to get a rate of return for the building and the shareholders and have maybe some quality of life impact, going forward. That would be helpful for everybody.
Great, thank you. And now, I think the deadlines are looming as we discussed. People feel a lot of pressure to get it in by May 1st, but I think there's a little wiggle room, right?
Yeah, so that was the good thing, right? So yes, the letter of the law said May 1st, 2025 was the original deadline for Local 97 compliance. And in particular too, Local 84 was always due on May 1st, and Local 88 was something that was due this May 1st. The good thing is June 30th there is a grace period. So for Local 97, so all buildings have until June 30th in order to comply without any penalty or prejudice or anything against that, which is automatic. The good thing is, as of yesterday, just like Matt was alluding to, the Local 84 also has that same extension through the end of June as well. So not only is 97 going to just have an automatic grace period, Local 84 also has the same grace period now as well. And if as long as 97 has a grace period, Local 88 does as well. And then if you still needed some additional time to file, there is a mechanism for us to put in for an extension to grant this through August 29th, which would also allow us to do Local 97 filing by August 29th, as well as Local 84 and Local 88. So we definitely have the ability to kind of stretch this May 1st deadline all the way to August 29th if buildings either can't file in time or sometimes the data just doesn't suit. Like we do find data from kind of that, sometimes is wrong. We have to go back. So there is a mechanism in the law that is allowing us to kind of, make sure we do it correctly when we submit this report.
Right. Yeah. And I think there was also some, is this really going to happen? Are they really serious about this? So I think this gets buildings that weren't 100% certain this was certain, their ducks in a row, which is good. And then as far as, fees are concerned, what are people looking at?
Yeah, in addition to the filing cost for, an RDP and the rest of the team to do it, there actually are DOB fees that I guess everybody has to get their cut, right? So the DOB requires $145 per covered building when we submit the reports. Article 321 extensions, there's no additional DOB filing fee for that. But again, violations are, $268 a metric ton if we exceed the carbon threshold. And there was a slide earlier that if we didn't submit a report at all, that was basically $50,000 a square foot. Or it was $50,000 in that particular case, in order if a building did not comply with the law. So certainly there's always some fees associated with filing, and obviously there's violations for exceeding carbon thresholds, and there's definitely bigger fees if you don't actually file at all. So I guess from our perspective, it's just really for buildings to just make sure that they take the action to engage someone to take care of this in order to basically not have any type of problems with non-compliance. And again, I said most of the buildings that we certainly in the portfolio, at least 70% or more, don't have any carbon penalties through the first compliance period. So we certainly feel like, this is just sort of getting people's feet wet. And I think a lot of the bigger stuff will come when we hit 2030, but at least, again, we have to move forward now and do our filing for the first time.
Right. So they have, in 5 years from now, it's going to be really serious. But for now, they're giving some grace period. And then Matt, from the AKAM perspective, what are we doing as far as getting our clients set up for success and making sure that, they're not having to pay anything additional?
Yeah, like I said, we distributed a comprehensive filing package starting with every Article 320 building, meaning buildings that were due this May. I would say 99% of our portfolio is Article 320, either the standard pathway where you do this year, or the 2027 filing where you have just one rent stabilized rent control department. So pretty much every building that's due in 2020, the boards were made aware of it. They have their filing package. We are moving on to the 2027 buildings, which will be distributed once we have 2025s tied up, because that's where the immediate concern is with any potential fines. So the 2027 buildings are our clients who are due in 2027 will receive their filing packages probably towards the end or middle of the second quarter.
So, and if anyone has any questions after this, we've answered a question here and there throughout, but we welcome any questions now. But we also, will circulate the information for Michael and Mitchell at Empower. Everyone will obviously have Matt's information, and happy to reach out to him as well should there be any, further questions or discussion, because I'm, this is a moving target. But we really appreciated your time today. And I'm sure this, as more comes up with compliance specific to energy, they'll be reaching out. So thank you so much for your time, and thank you to our clients for joining us today. We hope this was helpful. We have recorded this, so we were happy to circulate this after we were done. And we hope you have a great day. Enjoy this beautiful weather that we're having. Speaking of positive energy. I'm kidding.
Thank you very much, everybody.
Thank you for your time. Bye.